Welcome to the Arrive Podcast, the U.S. immigration podcast for Canadians. Today we will be discussing what is called adjustment of status. And that is when somebody has entered the United States legally and they want to stay permanently in the U.S. They want to make the United States their home now and their permanent residence. And specifically, we will be talking about the spouse of a U.S. citizen coming here. You're married to a U.S. citizen, or you come and you get married to a U.S. citizen after entry to the U.S., and you want to stay here permanently, as well as employees. Maybe you came and you're working on a TN visa, and your employer has sponsored you for a green card to stay here permanently in the United States. The process of going from that non-immigrant visa, a non-immigrant visa is one where the intent is just to come for a temporary reason, to a permanent visa, or in this case, a green card that allows you to stay here on a permanent basis. The process of doing that is what is referred to as adjustment of status. You're requesting the U.S. government to allow you to stay here permanently. And eventually that can lead to citizenship. And people get that confused a lot. I had an individual actually get upset on the phone the other day, and he was mad because he wanted his wife to get citizenship. And I said, well, she can get citizenship. It's a process. First, she has to get a green card. Then after having her green card, and if you're married to a U.S. citizen, that's faster. But after having your green card for 3 years, then she can apply for citizenship. No, I just wanted her to have citizenship. I thought she could just get citizenship. Nope, doesn't work that way. You have to get permanent residence first. After you've been a permanent resident if it's through marriage, 3 years, if it's through employment, 5 years, then you can apply for citizenship. But you have to have permanent residence first. So that is the step that we're talking about. How do you get that green card that will eventually lead to citizenship? And that's what a lot of people call and ask is, hey, I want to permanently move to the U.S. I want to become a U.S. citizen. What do I need to do? Well, this is actually the second step. The first step is getting here legally in a legal non-immigrant visa. But it's the first major step in becoming a U.S. citizen is this adjustment of status process, getting this green card. And we see this a lot, especially this time of the year with cross-border couples. There are a lot of cross-border relationships between Canada and the United States. We're right here. We're recording this podcast. We can look out our window and we see that's Fort Erie, Canada, right across the way, and Crystal Beach right up there. Yeah, nice beach. It's fun to go to. But there are a lot of relationships between Canadians and U.S. citizens because of the proximity of the border in this northern border. So we deal with that a lot. And people coming to the U.S. and they want to stay here permanently, either they've been married for a long time and maybe it's a transition in their life to a different period, maybe retirement, and they want to make the U.S. their residence now, or they're newlywed couples. And I don't think people enjoy long distance relationships, especially after marriage.
Yeah. And I mean,
really
even when they're
together.
not long distance. So I had a call last week from a couple, and one of them's living in Niagara Falls, New York, and one is living in Niagara Falls, Ontario. And they literally can see each other's houses across the river. But it's, considered a long distance relationship because you have to cross the border every time you see each other. And, there's no guarantees that you're going to be admitted every single time. So, when they decide at that,
and then COVID hits.
Yeah, then COVID hits and changes everything for everybody.
May not be able to see each other for a while,
right? And so they've decided they want to make their home in the United States. They're recently married, and now we're going through the process to get the Canadian spouse their permanent residence in the U.S. So they won't have any problems traveling across the border, and their intention is to live permanently in the U.S.
Yeah, and in another situation we see a lot too is individuals that are here working. And they've come to the point where they've decided that they want to make the United States their permanent residence, and their employers sponsored them through the process to get a green card as well. So those are probably the most common situations that we see, either through relationship to a U.S. citizen or through employment. And we also run into, children that have become U.S. citizens that sponsor their parents, or a parent bringing over a child who's not a U.S. citizen. So that all works out as well. But in this case, we're talking about those that are here legally on visas in the United States, or Canadians that are visa exempt, that have entered as Canadian visitors, and they have a method to become a permanent resident through what's called adjustment of status. So there's a couple steps to this process to transition from that non-immigrant visa over to a green card or permanent residence here in the U.S. If you are sponsoring a spouse, the U.S. citizen spouse will file what's called a petition for alien relative, and that's through a form called Form I-130 with USCIS. And what the Form I-130 does, or this petition does, is it validates the relationship. That's the sole purpose of this filing, is to validate the legitimacy of the relationship. You file it with the U.S. Citizenship and Immigration Services with supporting evidence to show, for example, if it's your spouse, that it's what they call a bona fide relationship or a real relationship, one that's entered into for love and not for simply immigration benefits. So it has to be adequately supported with evidence showing that you are, in fact, a married couple. And if you've been married longer, it's typically easier to show that, right? Because you have years of evidence.
Or children.
Ding, 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 ding. If you have children, that makes these cases much easier. USCIS or immigration looks kindly upon couples who have children. But if you haven't been married very long, just got married, then it might be a little bit more difficult for you to prove.
If you haven't merged your lives yet, sometimes it's more difficult to prove that it's a bona fide relationship. So, there's certain kind of financial evidence they look for that they really like. You can give pictures and things like that, but sometimes it's just not enough. So you got to work on collecting that evidence to make the case stronger.
Yeah, and when you're young, married couple, typically you're not going to have children. Like you said, you're not going to have joint finances yet. Or if you do, you have a month of bank statements or something, really short term. Maybe you don't even have a joint lease yet, but you have photos together. You have, taken vacations. You can prove that you dated and developed this relationship. But a lot of that evidence that the government likes to see is developed over time. Now, if it is a new relationship, they do, apply some discretion in that regard, but you still need to prove it. You still need to show evidence that you are in fact married.
Right. You can't just file this with just the marriage certificate and say, well, that's proof enough. We're married. There it is.
And you would be surprised at how many people say, this is my wife, or this is my husband, or this is my spouse. Look, here's my marriage certificate. We're legitimate. What else do they need?
And that may have been sufficient back 20, 30 years ago, but it isn't anymore.
It was. I had a client who told me they just walked in, and we had to actually redo this couple's green card because they moved to Canada for like 30 or 40 years after they'd lived in the U.S. So he gave up his green card and had to reapply again. The first time he got it, he literally walked here in Buffalo. He said they just walked in with their marriage certificate together. They printed the green card in the back and they walked away. It was that easy. Well,
if only that were the case today.
Not anymore. Yeah. You have to go through this whole petition process. So you have to file that petition for a relative. If it's an employer, it's a different process, and we're not going to get into the weeds on that. But essentially, an employer has various different methods by which they can petition an employee and show that they have a need for this employee to be here permanently in the U.S. And that's through a different form called a petition for foreign worker or Form I-140. So you have to have one of these approved in order to then take the next step to adjust status in the United States, either through employment or through a family tie to a U.S. citizen.
The good thing is for Canadians, in most cases, you can file these together. So you can file it as a one-step application. So even though you need 2 steps approved, you can file them all at the same time. And that's very common too, especially with married couples and family members filing the Form I-130 with the adjustment of status application all at once.
Yes. And then So, and that's the second application is the adjustment of status of the 485. So the I-130 or the I-140 is filed by the petitioner, the U.S. citizen or the U.S. employer.
Mm-hmm.
The second application, the 485, is filed by the
applicant.
foreign national. So the person being petitioned files the 485. And what the 485 essentially is an overview of the individual's background and their what they call admissibility to the United States. They're vetting you to make sure that you don't have a past, a history, or a tendency that would be harmful to the United States or to others. So that's what the 485 is. That's filed by the foreign national or the foreign relative, and then the I-140 or I-130 is filed by either the spouse or the employer. And like you said, you can file these concurrently or together at the same time. And if you do that,
a lot of
it
cases
processes
you
faster.
can.
Yeah, most of the time.
Yeah.
In employment cases, you see sometimes you don't, but almost every family case you do.
Well, certain family members you can't, right? So
if it's permanent residence, it depends on the wait time.
Right. For brothers and sisters, you can't. There's a wait time for those, so you can't file them together.
But if it's a mother, father, spouse, or a minor child of a U.S. citizen, there is no wait time. So those cases, you file those together right away. Along with the evidence to prove that this relationship is valid, or along with the evidence that the employee, if you're sponsoring an employee, has the qualifications.
Right. So when you file all at once, you're requesting that the government approve your relationship and say, yep, this is a legitimate marriage, a legitimate, relationship. And you're also asking them to approve your change of status from visitor or whatever it was, TN visa, to permanent resident. So it's a two-step that's all filed together as a one-step application.
Yes. And then along with that, there's some other things that are filed, right?
Yep.
You're not just filing that's the main thing you want. The main thing you want is the green card in the end. But then there's a couple components. One of them is affidavit support. Right. What is the affidavit support? Well, financial support. So they want to make sure that people that are coming to the United States aren't going to be destitute when they get here, that they're not going to live off the U.S. government. So there's a form that has to be filed along with the application to prove that the sponsor or the petitioner has the sufficient financial means to support the person that's coming over. And that's
actually, that form is a contract between the federal government and the petitioner, which puts a petitioner on hook to...
For how long?
It depends. And it could be until the death of the, it's for pretty much until they are self-sufficient. So until they have 40 work orders or 10 years of work history in the United States, citizen. Or they die. It does not, that obligation does not end by divorce either. So if that relationship ends, that financial obligation still stays in place. It's a pretty, concrete contract between the petitioner and the federal government.
And we get those questions a lot. So affidavit support is a contract with the U.S. government between the petitioner and the U.S. government. So like you said, you get divorced, this contract stays in effect. It does not go away just because you got divorced. It can terminate if,
citizenship, if the
citizenship,
right.
Death, 10 years or 40 quarters. Right.
Or if you get divorced and they remarry someone else who petitions them, then I think it ends it as well.
Or they depart the United States.
Oh yeah,
and they abandon their status.
Yes.
But in most cases, if they come and they stay here, well, you could be on the hook for 10 years as a sponsor, even through divorce. And this comes into play, if it's a legitimate relationship, most of the time you don't have anything to worry about. You're going to sponsor your spouse and you're going to support your spouse, right? But in some situations, the sponsor doesn't have sufficient financial means. And in that case, they would get a joint sponsor. And that can be any U.S. citizen or U.S. permanent resident. That can be step in as a financial joint sponsor to make up the difference in income, or to use their assets or income as evidence that, the person being sponsored.
And that means the federal government has two people on the hook now. So it has the petitioners on the hook and this joint sponsor on the hook to financially support this new immigrant to the U.S.
Yeah, and a lot of people don't understand the significance of this affidavit of support, but it's important that you do, especially if you're a joint sponsor.
Yeah, and the obligation's the same for the joint sponsor. It's the same timeline, so you got to be aware of that.
And I just had a couple that it was a cross-border couple, Canadian American, and we helped with the initial green card. And when the marriage is less than 2 years, you actually receive what's called a conditional green card that's only valid for 2 years. And in that 2-year time period, they got in a divorce. And the parents were the joint sponsor.
Oh, wow.
And they were not happy when they found out that
the marriage ended.
That they were still on the hook,
yeah,
even through divorce. And they wanted to, kick the husband or ex out. They didn't want to be on the hook financially. They wanted to know what they could do to terminate this.
Yeah, there's no terminating it.
I had to be the, bearer of bad news that, hey, you're on the hook. Divorce doesn't end this unless he leaves the United States, which he does not have to. He can stay. Then you're on the hook. They were not happy to find that out. Another thing that you file along with these applications is work authorization as well as travel authorization. And this is a key point to consider because these applications can take a long time to process. Depending on your processing location, you had one in San Diego. What was the time of wait in San Diego?
Oh, it's still not adjudicated.
Still not.
That couple moved too, so they prolonged the timeline by changing.
You can shoot yourself
forum.
in the foot by doing stuff like that, right?
Yeah, they moved from Arizona to San Diego, and they would have been
from one long time to even longer time.
But they would have been approved by now if they hadn't moved because the timelines where they were are still shorter than what it was in San Diego. But they're still waiting for their green card. That couple.
It's been over 2 years, right?
It has been, yeah, definitely.
Yeah. Whereas if you file here in Buffalo, it could be
we had cases
2 months, but
2 months,
on average about 6 months in Buffalo. So it depends on where you're filing. It can be a matter of months or years.
And the reason it's so hard for people is because once you file an adjustment of status application, if you're here as a visitor or on a TN or in some other non-immigrant status that doesn't allow for what's called dual intent, meaning that you have the intention, dual intent means you have the intention to live in the United States, but you can also hold the intention to be temporarily in the United States. You can hold a temporary status at the same time as applying for permanent status. TNs, that's not allowed. Visitors, that's not allowed either. You can only have one intention, which is temporary. So when you apply for adjustment of status, you essentially are stuck in the United States until you get authorization from the government to leave the U.S. No one's going to stop you from leaving. So if you were to drive across the border, there's nobody standing in your way. But to come back in would be a major issue.
You abandon your application.
And you've abandoned your application.
Start all over.
So all that money and all that time and effort.
I just had a client do this. They were married. They filed for their adjustment. And then the husband calls one day and, we clearly advise don't travel, don't leave the U.S. She said she had an emergency to go, I think, visit a relative in Canada. And he says, okay, what do we do to get her back? I'm like, well, now that her interview was only a few weeks away too, which was the crazy thing. She got scheduled for her adjustment interview. She would have just stuck around for another month. She would have had her green card. Well, what happened? Well, she abandoned that adjustment application. Then she was in Canada, and then she had to wait for a consular interview in Montreal, which she finally got a year later. So it prolonged her case by more than a year because she traveled, and she wasn't able to come back in because she had already declared her intent to stay here permanently, and you can't do that as a visitor. And she had already filed that adjustment. So
it's too bad she didn't call you before. There are ways to do that. I mean, if you have an emergency, you could file for emergency advance parole.
And it turns out there wasn't a true emergency. But
oh, wow.
That's another sense.
I had a client that did have a true emergency, and she ended up going into her local field office and made an application for advance parole.
Yep.
And she was approved for it, and she got to travel back to Canada to be with her ailing mother while she was passing, while her immigration case was processing here. And she was readmitted to the United States after that time without an issue because she went through the proper means to get emergency advance parole.
And they will grant that for humanitarian reasons. But because you just want to go visit your sister or whatever it might be in Canada that you haven't seen in a few months, that's not going to fly.
And it's really hard for Canadians because we're so close. Like you said, we can see Canada right here. It's so easy to go back home. So you really have to be committed if you're going to start this relationship, or not the relationship, but start this process, to not traveling back to Canada and have your family come visit you while you're going through this process.
Yeah, it's funny. And undoubtedly, every time, so I talk to Canadians that come here, they're coming on a TN visa, and we prepare them for that application process. And I always ask, have you ever worked or lived in the U.S. before? Because that's a question they ask you at the port when you're applying. And I had a client last week say, no. And I said, what? I said, you're Canadian? She's like, yeah. I was like, you've never traveled to the United States before? You've never visited? I can understand you haven't worked in the U.S. She's like, oh, I thought you just meant working. Yeah. She's like, oh, no, I've visited. It is so common. And to have somebody to say no, I'm like, it boggles my mind because
there's very few Canadians. Well, they love to travel, and the U.S. is so close and such a nice destination. And you rarely meet a Canadian that wants to live permanently in the U.S. or come here to work that hasn't been here already at least to visit once, you know?
Very common. So that is a major consideration is travel, but also work. Can you go? So if you're here and let's say you enter it as a visitor, you could be without authorization to work. Right now, they've sped it up. So we were seeing a work authorization come in like 3 months.
Yeah, but not travel.
Mm-hmm. Travel, sometimes you don't even get it. Sometimes you get your green card before you get travel. But work authorization, you have a good chunk of 3 to 6 months, depending on your situation, where you may not be able to work or travel.
Yeah.
So you could be stuck in your house, for a long period of time without
a source
financial
of income,
means, and the ability to travel. So it's something you really need to take into consideration. You need to be able to sit tight. Now, there are exceptions if, like you said, depending on the visa you're on. For example, if you're on an H-1B visa or an L-1 visa, you can travel while you have a pending adjustment.
Because those are dual intent.
Exactly. Yeah. But if you're on a TN, or if you're on a visitor visa, which is probably the most that we see out of anything, is a Canadian, just visa exempt Canadian who's seeking adjustment, you cannot travel. You cannot travel until you get prior authorization. And it can take some time. So you need to have that in the back of your mind. If you're adjusting status here in the U.S., there's going to be a long time where you can't travel or work.
But you know what? The way I explain it to my clients is it's a hard pill to swallow. But at the same time, would you rather, you can choose to be separated from your significant other for 2 years, possibly 2 years, going through the consular process where you're just able to visit and can't start your life in the U.S., or would you rather be together for a year while you're going through this process? Yeah. It's every family has a different perspective on it, but
some people have to work and they can't go without work, right? Yeah. Some people have to travel. Sure. Maybe it is for work or whatever it might be, and they don't have that, and they have to do.
Or they've been living a cross-border life, for maybe years while they've been separated, and they're just going to continue on doing that and choose to process at the consulate.
Yeah, we see that often as well. And that's the other option that we're not discussing today, and that's if you do it in Canada. If you finalize this process in Canada, that's called consular processing, and you process at the consulate in Montreal. They do all of these immigrant visa cases in Montreal. So
So if you need to travel, if you need to work, that's the better option for you. But if you can sit tight and be unemployed for a little while, then adjustment of status is
much faster too.
Yeah.
And that's typically what the discussion that I have with individuals who are trying to make this decision. That's the first discussion
Me too. I think that's the most important thing to travel?
Do you need to work?
Yeah.
Oh, no, I don't need to. So you could come to the U.S. and sit here for a year. It doesn't matter? Oh, yeah, I could do that. Well, okay. Adjustment might be right for you.
Right.
Oh, no, I can't go. Oh, no, I have to travel. Oh, I have to work. Well, then you're going to be stuck with consular processing if that's the case.
Which is still it's still a good viable option. We have people getting approved all the time.
Green card.
That. Yeah.
It just takes a little longer.
Yeah, you got to, be separated.
In some cases, yes. So those are the typically the two biggest factors that people consider when determining whether they want to adjust. And then another factor is intent. So when you enter the United States, and this is a big one that a lot of people don't understand, when you enter the United States as a visa-exempt Canadian, you're entering as a visitor, and they're admitting you in that status to the United States. And as a visitor, your intent at the time, and this is important, at the time of entry must be non-immigrant or temporary in nature. Your intent to come to the United States when you're coming in must be to return to Canada. It should not be to stay here permanently in the United States. If you do that, you would be in violation of your status and your intent.
And we've
to
had
come
calls
to the
like
United
that
States.
where people got some bad legal advice, or they just didn't get any
Showed up at
legal
the
advice
border.
at all, and they showed up at the border and said, "Hey, and they said, what's the purpose of your trip?" And they said, "Oh, I'm moving to the United States. Me and my husband are going to come live here now."
Law firm writes them a letter,
Oh yeah,
tells them, "Hey, just carry this letter. You're fine."
yeah, and you don't want to do that. So
No,
when
that's
you're
not good.
coming in as a visitor, you need to really have the intention to return back to Canada.
And the other part of this intent conversation is that intent changes, and it changes all the time. So your intent can change in the future
Yeah,
after
especially
you've entered the U.S.
During COVID, it changed a lot.
Oh, a lot of
would
people
be here as visitors, and they'd say, "Listen, if I go back home, I'm not going to see my spouse for who knows how long because the border and all these issues. So we're going to file."
Yeah, and so they say, "Yep, I've changed my mind. I
Mhm.
was going to go back to Canada. Now I'm not. I want to stay. I'm going to file for adjustment." And there are timing considerations there too that we're not necessarily
Right.
going to get into in this call or in this conversation, but there are timing considerations too that you need to be aware of if you've entered as a visitor. It can be done though, and that's the most important thing. If you enter as a Canadian visitor, or if you're here on a TN visa, even though these are non-immigrant visas, you can go to a green card, either through employment or through family sponsorship, as long as it's done correctly and you consider all the timing considerations involved in it. But intent is a big factor.
Sure.
And people look past it, and they may say something at
do.
the border. And remember, conversations at the border, at the consulate, they're often recorded and they're annotated somewhere.
Yeah.
So you say something at the border and then you contradict it in your adjustment interview, you could be in trouble
Right.
for
And
fraud.
the hard part is when it comes up at the adjustment interview, you're literally at the last step in the process. So you've filed everything, you've paid everything, you've waited all this time. And then you go to that final step, that interview, and the officer asks you a significant question, which you may know or you may not know is as significant as it is, and you answer incorrectly, what they deem to be incorrectly, and they can make a determination that your intention upon entering, violated the terms of your non-immigrant status, and therefore you were inadmissible at the time you entered, and they could deny your green card.
And they like to call that fraud. Because
Yeah.
you said one thing and did another. You lied
Right.
upon entry. And
Right.
yeah,
So be
you
very
knew,
mindful
you knew your
of this
intent was to
factor.
get a green card all along. And you should not have entered on a visitor visa to do that.
Correct.
So in those cases, it's strongly advised, use a competent attorney to help you with that process to make sure you do it correctly, because it is very easy to make a mistake in that process if you don't understand how the law works. So after you file these applications, you file for adjustment of status, and you're filing for your work and travel authorization. What happens is U.S. Citizenship and Immigration Services is going to issue what's called a receipt. And the receipt is confirmation that they have your case and it's going to be adjudicated. They're going to be reviewing your case. And everything you file has a receipt. USCIS loves mail. So you're going to get an I-130 receipt, I-45 receipt, a receipt for your work, a receipt for your travel. All of these are going to have receipts confirming, and they're all going to have their own little case number attached to it.
Do they come in separate envelopes, or are they going to come all together?
In separate envelopes.
Right. So I think that USCIS is financially supporting the U.S. Postal Service, frankly, but
Yeah, there might be some political agenda there. Yeah. Could you imagine USCIS stopped delivering mail? It would probably put the U.S. Postal Service out of business.
Well, that's the amazing thing, because the Canadian immigration, I find it's, they're relying heavily on email now.
It's all electronic.
Yeah, but U.S. immigration, we still do everything by snail mail.
And which is important too, though, because you know that these notices are coming by mail. You better keep your address current, and use an address that you're going to be getting mail at, and that you can respond to notices and stuff from USCIS.
And that's another benefit to having a competent immigration attorney. They'll be able to get copies of all your notices.
Yeah, your
so they're
attorney
going
gets
to
a copy
keep
of
you.
everything.
They're going to keep on top of you with these steps. So even if you're not home or you're traveling or you're not consistent in checking your mail or getting your mail, your attorney is going to be able to get copies of those and keep you on track.
Yep. And if you miss, and then the next thing, you're going to get receipt notices. Typically, the next thing you're going to get, typically a month or so after you get your initial confirmation that you received your case, is what's called biometrics. And this is an important step. All the steps are important. Now, if you miss a biometrics appointment, guess what happens?
Good luck.
Your case is automatically denied. If you miss it and you have not properly notified USCIS that you need to postpone that biometrics for a valid reason, then your case is automatically denied.
Yeah, because biometrics is an in-person interview, not necessarily an interview, but it's where you show up in person to give your fingerprints, and they take a photo of you in order to run your background checks, to check out your criminal background, to make sure that you're admissible to the United States, and that you don't have any criminal background or history that would impede your ability to get a green card. So it's very, very important that you show up for that at the right time in the right place, and if you can't, to notify them in advance.
And they have to approve the reschedule. So if you notify them in advance and then they didn't get back to you that they rescheduled it, you better still show up, because if they don't reschedule it and you miss it, you will be denied. And we've unfortunately seen this happen a few times recently, where individuals have ignored those notices and their cases were
and
denied.
I think they've gotten harder with those lately. I feel like before COVID, we were able to send people into
just walk in.
Yeah, or
anywhere
even,
you wanted.
Yeah, even other field offices.
Yeah.
If they said, "Oh, I'm not living there now. I'm living over here. Can I go to this field office?" Yes, you can, but not during COVID. They changed that rule.
Yep.
So they're not as lenient anymore, and it's very important that you honor all of these notices that you're getting and show up on time in the right place.
Yes. And another thing that goes along with that as well is a medical. So every immigrant to the United States has to perform a medical evaluation and make sure that you don't have any, communicable diseases that are a threat to the population of the United States. Make sure you have all of your inoculations, they're up to date. One of the most recent ones that's on there is COVID is now required as part of that process. You can file that medical along with your initial application, or you can do it later on. There's actually 2 times you can do it. And we typically don't include the medical up front. We include it later on. They'll request it later, and you can submit it and bring it to your interview with you. And that's because these medicals do have an expiration date. And with COVID, a lot of the delays, people's medicals expired.
Right.
So they'd have to get another one. So you're going to go through a background check with the biometrics appointment. Make sure you attend it. And you're also going to have to do a medical check.
Exam, yeah.
And not anybody can do this medical. You can't just have your primary care physician fill this out for you and bring it to you. They have what are called designated civil surgeons, and only these civil surgeons can do these medicals. You have to have it done through them. They return it to you in a sealed envelope. They'll give you a copy as well for your records, but that sealed copy is what is delivered to USCIS, either with your application by mail or in person at your interview.
Yep, and this medical is not covered by your health insurance, so it's going to be something that you have to budget for and pay out of pocket for personally. So it's
if you haven't been vaccinated, if you haven't got all your vaccinations,
you're going to pay for that too. I had a client recently tell me that their medical exam with the vaccinations they needed to get cost them upwards of $700.
Oh, wow.
Yeah. And so it's something you want to budget for as well during this process. And that's another reason we kind of wait to the end to tell people to get it, because there's a lot of expenses right up front with the filing fees. And if you're using an attorney, legal fees, sometimes it's nice to have a break from that before you have to pay for a medical exam as well.
Yeah, spread those costs out.
Yeah.
But it is an absolute requirement. Okay, you have to get this medical done for them to approve your case. And along the way, as USCIS is reviewing the materials you submitted and processing your case, they can issue a few different things. They can issue what's called a notice of intent to deny, which means your case is very deficient.
Right.
Or they can issue what's called a request for evidence, which is simply a notice from USCIS saying, hey, we got your case. It's
we need
missing
more.
this or the other, right?
We need more to make our decision.
And there are some common ones we see for
sure.
a request for evidence. I would say the most common NOID that I've seen is people will submit, just like we discussed in the beginning, they'll submit their application and it's a marriage case and they'll just submit it with their passports.
And let's be clear here. We're seeing these because people are calling us after they've submitted their case on their own. It's not because we filed insufficiently. Usually people
come for help.
Yeah, they've tried this process on their own and they've run into a little bit of a roadblock and they want our assistance to help them get out of the hole now.
And I just responded to a NOID for a couple and they came to us, they filed on their own, and literally the only things that were in this application, and this is not a knock on them, they just don't understand the process, right? We do it all the time, so for us it's inconceivable that somebody would file like this, but from a lay person that's filing, they think it's okay. But their application just had the forms.
Yeah.
Then it had proof of citizenship for the U.S. citizen, birth certificates, and marriage certificate. That was it.
Yeah, acceptable maybe in the 1970s, but now that's not going to be enough.
They got annoyed.
Yeah.
Saying, in other words, this is so deficient on its face
that we can deny
that
it
we can
outright
just outright deny you
if
right
you don't
now.
respond to this,
Yeah.
right?
So they had no bona fides. They did not have any of that evidence that we talk about that you need to prove the relationship.
It's a pretty common mistake. I think people feel like their marriage certificate is enough. Unless you read the detailed instructions for the form, you wouldn't really know that off the top of your head. So
it is very common. So annoyed. And the other is a request for evidence. So requests for evidence are actually not that uncommon, and USCIS unfortunately will issue them sometimes unnecessarily. Maybe they haven't reviewed the evidence thoroughly, but we'll see requests for evidence for stuff that we've already submitted sometimes.
I've seen a lot lately, and this is even for ones that we did file for the financial information. So even sometimes where you meet the financial requirement and you submit sufficient evidence to demonstrate that, they'll still send a request for evidence asking for a joint sponsor. I don't know what it is these days, but they want their comfort level up before they approve that.
Or they'll ask for a marriage certificate and it was included.
Yeah, and it's frustrating because people call us and they're like,
delay your case.
We sent in everything, to prove this and our income is enough. What's going on? And sometimes the best thing to do is just get that joint sponsor, just send them what they want in order to move the case forward rather than try to argue with them that what we already sent is sufficient.
And then some of them are legitimate. And I think some common ones that I've seen over the years where people have come for help is, let's say you submit a marriage certificate, but you got married in a foreign country and the marriage certificate's in a foreign language, and you did not include a translation of that. That will get a request for evidence.
Yeah.
Or maybe you are Canadian and you were issued a short form birth certificate and you never got a long form birth certificate. They'll request that long form birth certificate. That's another one we see often too. And then just simple requests for maybe the document you submitted was cut off.
Oh yeah,
it wasn't include the entire document, or it wasn't legible
on it or something. Yeah. So that's a good reason to use an attorney, is because we know what the documents are supposed to look like, and we know which ones are acceptable, and we'll tell you like, hey, you need a translation before we submit it, saving you sometimes months of processing.
Or this short form is not sufficient, you need the long form, right?
Yeah.
Or that that religious ceremony that you did is not legal proof of marriage. We need to show where it was actually registered, and we need the registration of that, religious ceremony. So it depends. Yeah. So those are all things that USCIS can request information for. So they call them requests for evidence. So they're not the end of the world. It's funny though. We get the mail. You check the mail. Then these notices are typically on white paper, or some of them on this light shade of green.
Yeah.
But a request for evidence,
yellow,
pink, like they're a bright colored
paper.
Piece of paper. So you'll know
pay
if you're
attention
getting
to
one.
me, right?
Yeah. Do not ignore. And again, circling back, make sure you keep your address current, because if this notice comes and you moved 3 months before and you don't see this notice, they could deny your case for failure to respond to this notice. So you could be out of luck. So make sure that address that you're using is current, and you're checking your mail often when you do this. And then the final step when you go through this process is the in-person interview. And if this is based on marriage, it always culminates in an interview. Every case, you have to have that interview with USCIS.
And I think there has been movement towards trying to eliminate that requirement, because it's, pretty onerous, and in some cases it's not necessary.
Yeah, if it's on his face, his case is, 5 inches thick of evidence.
And they've got 4 kids together, and they've been together for 15
those
years.
Ones,
yeah. There's really no need for an interview. Other than meeting the person face to face and verifying their identity. I can't really see anything else. Maybe verifying the security questions.
Because they do waive a lot of employment-based ones, or for parents and children, they'll waive those.
So there has been movement towards, maybe not requiring the interview in every
right
case.
Now,
but
they do.
Currently, every case is interviewed.
So what happens if you don't show up?
Yeah, denied.
Your case is denied. What happens if you show up without your spouse? Your case could be denied.
Although I did have a case that I was waiting patiently at the field office, and the client didn't show up, and I gave them a call while we were there, and they had totally forgotten. Someone had gotten sick in their house, and they couldn't make it, and they completely forgot about it. But we got it rescheduled because I was there. So because you had an attorney. Yeah. Otherwise, their case
you
showed
been up
denied.
in their stead, and then you got it rescheduled. But if you flat out just don't show up to that interview, they're going to deny your case. And if it's a marriage interview, your spouse should be with you. That's what they're doing. They're verifying the legitimacy.
Well, you get a notice that tells you everything you need to bring and who you need to bring with you. So read it. Yeah, read it.
Not a lot of people read. And what do you bring to that interview? And it says on the notice what to bring. But the stuff that you've submitted by mail, typically you don't need to bring any duplicate evidence. But you need to bring your originals. So biographic documents, so marriage certificates, birth certificates, naturalization certificates, passports. They want to verify originals of that. And then any additional evidence that you didn't already submit. So maybe it's been a while since you filed your taxes and you have a new tax return, or maybe you've had a child since you submitted your application, or now, and I call this gap evidence, maybe since you filed, you have 6 more months of bank statements or rent statements or insurance statements. All of that evidence that you've accumulated since you filed the application, they expect you to bring and to that interview and show it to them, to prove that, hey, I filed this a year ago or however many months ago, but we are still married. We're still in a relationship. Here's that evidence that we've accumulated since we filed it. And then sometimes the officer will ask for it. Sometimes they won't. If they do, then you have it. And you can give them that evidence to prove that you're still in a legitimate relationship.
Yep.
Then at the end of that interview, all goes well. Typically, here in Buffalo, you'll get your green card within a week. It's pretty fast. And then you're good to go. You're a U.S. permanent resident. So 3 things to consider if you're filing an adjustment application. And we've covered these briefly. But number 1, make considerations for travel and work. And this, again, this is one of the...
In making your decision on how to proceed, really think through what your family can handle as far as your work obligations and travel obligations for the foreseeable future, because it could be a while.
cabin fever.
Yeah.
You could have some severe cabin fever if you're stuck in your house during the winter and you can't travel or work. So that is one of the top things to consider is whether or not you need to work or travel. And that's going to determine whether or not consular processing or adjustment of status makes sense for you. Second, plan ahead. As we've discussed, this process can take 2 years. It could take a year. It could take several months. It depends on the processing with the U.S. government. But you need to plan ahead for this. You need to plan ahead. If you want to do it in the United States and adjust status, and you need to rely on income, maybe you need to put some money away in savings that'll allow you to sit tight for a few months. Maybe you have a vacation. Maybe you want to postpone a vacation until later on, until after the process is done.
Right.
Selling homes, there's a lot that goes into this.
Yeah, but you got to be careful with that too, because if you think about the intent issue and the steps you're taking prior to coming to the United States, you really have to have that intention to be a visitor, to enter and to return to your home country. So you should work with an attorney that, is familiar with this process to make sure you're not taking the kind of steps that are going to impact you at your interview down the road.
Yep. And that's the third one, intent. Very important. And that might as well be the most important on the list, but it's one of the three, right?
Yeah.
That intent. And again,
that planning and intent, right? That's a balance. So you got to work with an attorney that knows what they're doing. Yeah.
And really all three of these go together, consideration of travel work, you need to plan ahead, and what is your intent at the time of entry?
Yeah. Bad planning can derail your case. Cause I had a client who, was coming in as a visitor. She wasn't even intending to adjust status. They had already got an approved I-130 and they were going through consular processing, and she was coming to visit with her dog or her dog. No, it was her cats actually. And she had several cats with her, and the officer took the position that, nobody travels with their cats unless they're moving there. So she was denied entry to the U.S. and she wasn't even intending to immigrate, but she had a U.S. spouse. We were going through consular processing.
She was intent, right?
Right. They perceived it as intent, and they denied her as a visitor.
Yeah. So, and we've covered some of these examples already before, but one of the most common ones we see is people that have been in a long-term relationship with a U.S. citizen, and they've come to a point in their life where they want to retire. And I'll say Florida because that seems like everyone wants to move to Florida.
Or Texas.
Or Arizona, one of those warm states. And they just want out of Canada, and they're going to retire and move to the United States. We see those cases on a regular basis. So make sure you plan ahead if that is in the cards and that's what you want to do. It's not something you can just do overnight. I'll ask people that question. Well, when do you plan on coming to the U.S.? And they say, we want to come down hopefully next month. Not going to happen. You're not going to be able to get a green card in a month at least. And they need to make sure that they consider the things that we talked about. Do you need to travel? Do you need to work? And plan ahead for that. So we see a lot of that. People retiring or maybe making a major career change, and they're selling a home and moving to the U.S. to take up a job in the U.S. These things, you need to make sure that you plan ahead and you consider this. If you have a marriage in the future, right, you're engaged. How is that going to play out once you get married? Are you going to have a cross-border relationship? Is one person going to move to the United States? Or is one person going to move to Canada? Are you going to consular process? Are you going to adjust? Definitely need to consider that. So hopefully this conversation was able to give you a good idea of the adjustment of status process, moving to the United States, and filing for a green card to stay here permanently. If you haven't already, go ahead and hit the subscribe button so that you can hear upcoming episodes of our Arrive podcast. We also have a YouTube channel out there with some great videos. They answer a lot of questions, and our website is a great resource as well. There we have regular posts that address common immigration questions come out frequently on our website as well, where you can go and you can subscribe to those weekly updates and get more information. Thank you for tuning in today, and have a great day.